Just for everyone's information, please sign in if you haven't already. There should be a sign-in sheet down in the south as well. We're going to, this morning, go through each one of the 4 regulation recommendations that's in the packet. We will give a brief introduction of each of the recommendations, and then at that time we will accept public comment on each one of them after the introduction. If you have any specific recommendations or a change, we would appreciate it if those were submitted in writing for our purposes. Other than that, I will go ahead and turn it over to Jessica Flood, the Northern Regional Behavioral Health Coordinator, who will begin by introducing the first recommendation. Thank you.
Hi, my name is Jessica Flood. As Stephen said, I'm Regional Behavioral Health Coordinator for the Northern Region. I just wanted to give a little bit of background. So my region is the Northern Region. It's Carson, Lyon, Douglas, Churchill, and Story counties. That was formed through AB 366 in the 2017 legislative session. And this board, it consists of law enforcement, emergency services, social services, mental health treatment providers, hospitals, etc. And these boards were created really to try to improve behavioral health in a regional way in Nevada. So each one of these boards through AB 366 had a bill draft attached to it. And for the Northern Board's bill draft, they chose to try to clarify and standardize the involuntary mental health crisis hold process in Nevada, also known as legal holds. And so in doing that, we put together a statewide work group that again assisted of diverse partners across the spectrum. Law enforcement, emergency services, we brought into the courts. So Washoe Court was a huge participant, including Judge Liu and her court clerk, Sean McCoy. We also had the public defenders up in Washoe County, including Jennifer Raines. Down in Clark County, we had a lot of participation from Master Yeager and some participation from the public defender as well. I also want to acknowledge the Washoe County DA for being a participant in a lot of the meetings. We had the hospitals, Nevada Hospital Association, Nevada Rural Hospital Partners, Nevada Psychiatric Association, the ER, Northern Nevada ER doctors, just a huge amount of partners coming to the table to really examine the process. And it's a very complicated process that affects many, many parties. So in developing the legislation, there were 4 areas that we saw a need for clarification. And also an opportunity to develop behavioral health transportation. And I'll go deeper into each of these as we move through each one of them. But really, there was a lot of confusion around the idea of medical clearance. When a patient comes in on a mental health crisis hold, they need to go through a process to determine if they have any acute medical issues. And there was a lot of confusion between the hospitals and the receiving psychiatric hospitals. So we tried to clarify that through process. Behavioral health transportation does not currently exist in Nevada. So our bill through accredited agents allows for behavioral health transport, and that really was to accompany the Washoe Policy Board's bill, AB 66, which also created a mechanism for behavioral health transportation. So we tried to bring those 2 bills together, those 2 mechanisms, into one regulation with cooperation from the Washoe Board as well. Currently, there's no data for mental health crisis holds in the state of Nevada, and that has been a huge gap in determining what the gaps are in our system, as well as the needs and where the pressure points are. So we wrote a regulation for that, to have hospitals provide that data to the state. And finally, there was no standardized policy throughout the state regarding involuntary administration of medication. So in Washoe and Clark, they had their own internal processes that were developed in collaboration with the Division of Public and Behavioral Health. But for the rest of the state, there really wasn't any understanding of what that process could look like. So we thought that with the regulations, you could turn to law and really see in a transparent way what that process would look like if you were going to go through that. So those are the 4 regulations we're going to go through today. Okay.
Okay, we will get started with public comments, so we will take them one at a time. For the first one, regulations governing mental health crisis hold data collection. Is there any public comment? And please state your name for the record if you are going to give public comment. Thank you.
So,
It's not on.
Joan Hall, Nevada Rural Hospital Partners. Good morning. First of all, I'd just like to thank everybody for the tremendous effort and the huge lift to get these regulations to the process they are right now. We had some concerns on the data collection in do you want me to tell the number specifically where I'm talking?
Yes, that would be helpful. Thank you.
R011201, and it's under section 6. It starts within 48 hours of discharge. We believe in our discussions that the disposition of the application for emergency admission needed to have more discussion there regarding referral to child welfare. If patients' parents or guardians were unable to be contacted, or if they refused the treatment that was suggested. I think that's just an oversight. We talked about that, but we think that's an important piece of data that needs to be collected. Thank you.
Thank you very much.
I'll put that in writing to you.
Thank you. Anyone else? Seeing no other public comment, we will move on to number 2, regulations governing behavioral health transportation services. Is there any public comment? Okay, seeing none, we will move on to number 3, regulations governing medical examinations required for admission to a public or private mental health facility. Are there any public comments? Okay, and the final one, number 4, regulations governing the involuntary administration of medication in a public or private mental health facility.
Hi, yes, I have a comment here.
Go ahead, please state your name for the record.
I'm Jessica Murphy. I'm here with Claudia Romney. We're both Chief Deputy Public Defenders in the Clark County Public Defender's Office. And I know I've spoken with some of you on this issue before. So our office is concerned about the proposal to eliminate the actual court hearings for the forced medications. The way it stands now is in Clark County, some of you already know the process, but we have, last year in 2019, we had over 15,000 commitment hearings. We have 300 new petitions every month. So we have hearings twice a week. Typically, the cases get continued for a patient to continue to receive treatment and ultimately discharge. If there's a forced medication motion, then the law requires that they first be committed to a behavioral health hospital. So we have a hearing on the commitment portion, and then we move right away then to the forced medication portion. So there's judicial review, there's the opportunity for the court-appointed lawyer, because we are automatically appointed to every single patient that has a petition filed against them. So these patients do have lawyers that are appointed. It's the same witnesses and evidence that would be presented for the commitment portion as to the DOR portion. The way I understand the proposal, it allows an individual hospital to determine if they're going to still motion the court for an order for forced medication, or whether it's going to allow it to use the internal process set up in this proposal. And a lot of the internal process specifically looks like Section 7, subsection 2, talks about the different rights that a patient would have With 24 hours notice, the patient would be expected to be able to essentially act as a lawyer and represent themselves at these hearings with some sort of patient advocate. There's no opportunity for the patient then to have an attorney to represent them, as is happening now, at least in Clark County. And if I'm reading this right, the final decision then, the final appellate option then essentially rests with the medical director, and it doesn't allow any sort of petition or motion to any court for any sort of review. So we're concerned now that we think that although the process that we have isn't perfect, we think that it works quite well. It allows patients that are already appointed an attorney to have that attorney represent them. There is absolutely law supports that the patients have a protectable liberty interest in being forcibly medicated, and I just don't see how allowing an individual hospital to determine if they're going to go to a court versus an internal review process protects those liberty interests. Additionally, I think that there's equal protection issues because you're allowing the hospitals to determine what procedure is going to be given the patients. And I'm not speaking for the private hospitals, but I don't see them necessarily changing the way that they do things now with petitioning the court. I know there's an issue with SNAMs, and I believe that they would probably use this proposed process. So you're having a situation where the hospital decides what process their patients are receiving, and you're going to have patients, indigent patients at the state hospital being denied their right to a court process when you have patients at a private hospital probably still being able to petition the court. So I think there's a lot of issues. I know I've raised these before. We are definitely not in support of the proposed regulations. That's it. Thank you.
Thank you. Is there any other public comment on this item? Okay. With that, we will open it up for any general public comment at this time. Okay, seeing none, I just want to thank you all for being here and expressing your interest in this process and these regulation recommendations. And we very much appreciate your feedback. Thank you. Have a good day.
So maybe we can have a conversation on this. Like, what if these private hospitals can't create the process? The reason and that's nice because when we were soundtrack, we were in the hospital.
Yeah, I know.
Right.
My mom's a provider.
Well, thank you for smiling.
Any other?
Right.
Just to change your core process.
Oh no, what's wrong?
No.
And I was driving around.
Okay.
Yeah.
That means I gotta check it this way.
And it wasn't flashing, so
It
interesting.
wasn't flashing, so it's
No, I mean, we tried to
It's
send
still
her back.
happening.
I don't know if
It's
you
still
probably
in
saw the
part.
first version, which is close to where you were at. And then the second version, like, yeah, we bent over backwards to try to make it happen.
I mean,